Senator Nessa Bush.
Thank you, Madam Chair. Madam Chair, I introduced this bill at the request of my colleague in the House, Representative Carol McEntee, who I believe was hoping to come over here today. And I know I had discussed it with you, but several states throughout the nation are beginning to look at parenting from a more uniform point of view, hence the name. I'm quite sure that Connecticut and I believe 2 other states in New England have enacted this, and virtually all of the New England states and many states throughout the nation are considering the Uniform Parentage Act. And, you know, it's a global world, and we are a much more mobile country. And as people move from state to state, there is some utility, I think, and value to people being able to count on similar norms when dealing with issues like parentage. Obviously, we also cannot ignore, and I know, Madam Chair, you were very involved in this type of legislation in the past, but as we have technology-aided reproduction, there are many issues that arise, and I know this bill takes a look at that and tries to make for some uniform policies having to do with technology assisted reproduction. Now, I also know from conversations with Chief Judge Fort that he does have some issues and concerns about jurisdiction, and I don't know if he has sent someone to testify on that from the court. But anyway, it is essentially the Uniform Parentage Act that is being introduced and debated across the country. And I know we have at least one attorney here to speak on it.
Thank you. And I do, just so you know, I did get a message from Sharon O'Keefe that she was planning to come testify, but she's ill, so she asked to be given an opportunity to hear her thoughts, which obviously will afford that to the family court. We have 3 witnesses signed up to testify: Michael Grant, Stephen Brown, and Randall Rose. Mr. Grant, we'll start with you. Welcome to the committee.
Yeah, good evening. Thank you very much. I'm delighted to be here to provide testimony in favor of this bill, with particular to the aspects of the bill that pertain to gestational surrogacy agreements and also to genetic surrogacy agreements. I'm a practicing attorney in this state. I'm also licensed in Massachusetts. My former wife and I, 27 years ago, attempted to have a child with the assistance of a surrogate mother. One of our good friends volunteered to serve as our surrogate mother, and I drafted a contract basically on my own. After some discussion with Judge Sattel at that time, who was a member of the Rhode Island legislature at that time, and he was kind enough to talk to me about it. He had some interest in this. And at that time, there were only 2 IVF clinics on the East Coast, one in Connecticut, one in Pennsylvania. We tried twice. Of course, the technology is not what it is today. There was roughly a 12% chance of success. But of course, my wife and I at that time, we had a desire to have our own children, our own biological children. We were both very fertile. However, my former wife, could not carry because of a deformity. And thus, a good friend of ours volunteered. In any event, it was completely uncharted in that there were no statutes at that time, 27, 28 years ago, governing surrogacy. There were only several state decisions, court decisions throughout the country there were some contested cases that did validate the contracts that the parties had entered into. So based on that, we moved forward and we took a chance, hoping that if there was ever an issue that the court here in Rhode Island would uphold the contract. But of course, we wanted to try this. We wanted to have our own children. We tried 2 embryo transfers. They were unsuccessful. We ended up subsequently adopting twins from the state of Tennessee. So I'm actually fortunate and glad that the procedures didn't work, because I have twin boys who are 26 at this time and are terrific. But in any event, Rhode Island still does not have a statute on surrogacy. And it's very popular. The technology has improved greatly. When a client would walk into my office 20 years ago, 22 years ago, and say, you know, we need a contract, we have a carrier, we want to move forward with this, I would help them, and they would sign the contract, and they would get screened and so on and so forth. We'd do criminal background checks on the carrier, on the parents. But they would leave my office, and I would say to myself, this probably is not going to work, and it wouldn't work. not until about 15 years ago when the technology improved to a point where now they're very careful, clinics are very careful as to how many embryos they will transfer. In many cases, only one embryo will be transferred, and that's incorporated right in the contract that I draft or I review on behalf of a carrier. Carriers do not want to carry 3 or 4 babies. They want to carry 1, 2 at the maximum, and so the contract does govern that. So I'm here to testify. I believe this piece of legislation is very positive. And actually, every element in this bill that governs the contract as to what is needed to be placed in these contracts is in my contract when I draft the contract. All the parties are represented by counsel. They're all evaluated medically, psychologically. There has to be, the first thing that I investigate is there adequate health insurance to cover the pregnancy and the delivery? Because the parents, which typically I represent, are on the hook as per the agreement. If the pregnancy is not covered by the insurance, the surrogate isn't going to get stuck with that. That's not proper, and that's not going to happen. It's the parents. So in representing the parents, I make sure that the insurance that the surrogate has for prenatal care and delivery is adequate and it does not have any exclusions for surrogacy. There are policies that are underwritten specifically for surrogacy. They're terrific. But there are also many, many policies out there that will cover surrogacy pregnancies, and it works out terrific. But in any event, this bill sets out the criteria, what needs to be in a contract. The parties need to be 21 years of age. Everyone has to be screened. And no IVF clinic that I've worked with in the last 15 years will work with any party where their surrogate is not screened, psychologically or medically screened. No one wants a disaster, and clinics are very cautious of their statistics. They want things to work out. They make sure everybody's screened. Of course, all parties are represented by counsel. This bill requires that at least one of the parties be a resident of the state of Rhode Island, or at least the evaluations take place here. So there is that nexus to Rhode Island. So it guards against people flying in from other states because Rhode Island has a favorable law. New York doesn't, so it prohibits New York folks from coming in here and doing this after the fact. When they realize they're in trouble under New York law, they're going to have to travel to another state, so it guards against that. The parents, of course, in the contract, all the parties decide and acknowledge that the intended parents will be named as the exclusive parents of the child. And the contract must reserve to the carrier to be able to make all decisions concerning that pregnancy. In every contract that I draft, it states that the parties acknowledge that the gestational carrier has the constitutional right to terminate the pregnancy if she deems appropriate. If her doctor deems that it's dangerous for her to continue carrying the child, she has the absolute right to terminate, and the parents have to accept that, or we have no contract, we have no deal. So this bill secures that. All pleadings relative to the court proceedings later will be sealed, which is fantastic. I file those motions with every single petition, whether it be in Massachusetts or Rhode Island. What I really like about this bill also is that with respect to the parentage orders, orders can be entered according to this bill before birth, the day of birth, or post-birth. And that's important because in my experience, many times either the parties aren't really cooperating, they're not filing their affidavits. I draft all the documents for them. The carriers are busy, they have their own children, they have their own lives. They don't get around to, seeing a notary and signing the affidavits. Here we are, and you can't predict when a baby's going to be born. They may be twins, triplets. All of a sudden, the carrier goes into labor. I don't have the pleadings to file with the court, and now I'm running into court the day of birth sometimes, or after birth. And in Rhode Island, thankfully, the judges have been acquiesced, and they've signed the orders post-birth. Sometimes there has been issues with vital records, where they've already created a birth certificate with the carrier's name already on the birth certificate, and now I come across with an order, and they're thinking, are you trying to circumvent something here, our procedures? And of course, that's not the case. I did have one same-sex couple where this happened, and I presented an order post-birth to vital records, and they demanded that the initial birth certificate with the carrier's name be returned before they would issue the new birth certificate, which didn't make any sense whatsoever, but in any event, I had to go back to court and get a new order so that the parents didn't have to return the initial birth certificate, so we straightened it out. But if we had this bill, all of that would be taken care of and addressed. Three other states, neighboring states, Connecticut, New Hampshire, and Maine, have statutes that were enacted within the last 3 years that are very similar to this statute, very similar. Things are working very well. Massachusetts has a pending bill that's under discussion this year. Things are moving very well in that respect. And Vermont is moving forward with a surrogacy bill very close, which resembles this bill very closely. So Rhode Island is one of the last New England states that really hasn't codified these procedures and these arrangements. And I think Rhode Island is, we're going to do it. I mean, folks that want children, want their own children, there may be some medical issue, they're going to try it. And it's just too bad that they have to go to other states that have more favorable laws or have a law to do this. It would be nice if Rhode Island did have a statute like this to govern these arrangements. Lastly, I would like to say that for years, I would present these parentage orders in the family court. Judge Jeremiah, maybe as far back as 20 years ago, and then his successor, Chief Bedrosian, consistently entered orders in favor of the parents. And recently, I've now had to present these petitions to the Superior Court. And Justice Gibney, I met with Presiding Justice Gibney. She was very much in favor of this. She felt the court certainly had equity jurisdiction to declare who the legal parents are of a child being carried by a carrier. In Massachusetts, there are three, although there's no statute there are three cases that are on point that give the probate and family court jurisdiction to entertain these cases, and they've been entering orders, parentage orders for years. But in Massachusetts, oddly enough, you can get a post-birth order. The courts will grant the post-birth order after birth, but Vital Records won't accept it. So, and none of the cases have been presented to the Supreme Judicial Court of Massachusetts, so they're stuck. In Rhode Island, I can obtain a post-birth order from Superior Court, but what happens when Justice Gibney retires? I mean, then things are in limbo again, and it really is dependent upon the Chief Judge. But if we had this bill enacted, that it would be taken care of.
Mr. Grant, can I just ask you a question in terms of going to Superior Court? Is that, are you getting some sort of summary judgment there, declaring the I guess the parents as opposed to the carrier? And are you having an issue with family court now?
Having an issue with family court, Chief Judge, the present Chief Judge of the family court, I had two cases that were filed in the family court when Chief Justice Fort took the bench as chief. He had serious reservations as to whether or not the family court had jurisdiction. And at that point, what I did was I then visited, I knew all along the Superior Court would probably have jurisdiction. I always felt they did, but I went to see Presiding Justice Gibney, who told me to file the petitions in her court.
Okay, thank you. Senator Lombardi.
Are they presented as DJ actions? Is that what you, a declaratory judgment?
They're miscellaneous petitions, and the parties sign a stipulation to judgment, and the surrogate does appear with her own attorney, and we do present some testimony. We have an affidavit from the doctor who does the embryo transfer, who declares in his or her opinion that this can only be the child of the parents, because what they do is the doctor provides hormones to the carrier, which prevents ovulation. So in their opinion, it can't be the carrier's child. And therefore, based on the expert testimony, based on the stipulation of the parties, the court enters the order. So it's based on the medical evidence and also the by stipulation of the parties.
And are you, Mr. Grant, and then Senator Jabbour, have you run into an issue where anybody has been forced to file an adoption if there's been, like, I guess what I'm asking you is it's just creating additional layers for these people who already have an agreement signed, they already have a contract. These aren't contests on your part. It's not like the carrier showing up and saying, no, this is my baby. We're just trying to make sure that everybody understands what their legal rights and obligations are after we have the child.
That's right. No, there have been no contests. I mean, it's presented to the court as a stipulated judgment, basically. We present a stipulated judgment. I have never had a contested case in the last in my 25 years of practice. I did have one contested case where the surrogate was also the egg provider, the genetic, she was a genetic biological parent. That was about 17, 18 years ago. Those types of arrangements are not popular because of the technology. Folks, of course, rather avoid that risk and just have a child, of course, comprised of their own genetic material and avoid the carrier also being the egg provider. But no, we have not. I've never experienced a contested case. There are a few throughout the country, and they've all been resolved in favor of the intended parents. The carrier is not the genetic mother. Family court is not going to provide her, at least in my judgment. Thank God I've never been involved in such a contest, but hopefully I never have to.
Thank you. Senator Jaboy?
I had a question. Thanks for your insight on this issue. It's very interesting. Are you saying that you have an agreement in hand with the carrier before the process begins?
Yes, before the embryo transfer, she's counseled psychologically, she is screened medically, and then she is provided with an attorney, and they review a contract together, and then we negotiate the terms. There's a lot of back and forth. The carriers are well represented, and then the contract's signed, and then the transfer takes place.
So when you utilize the Superior Court as a forum for purposes of adjudicating, that carrier does have counsel, generally the same counsel who represented that individual when the agreement was drafted, correct?
That's correct. That's correct.
Have you seen any change of heart, and how does the court deal with any resistance by the carrier at that phase of the litigation?
Thankfully, I've never experienced that in my own practice. The carriers that I've represented and the parents that I've represented who their carriers have never voiced a change of heart. And I can honestly say that in representing 300, 400 carriers over the last 20 years myself, and speaking with them and seeing them and going through the whole process with them, there's no doubt in my mind that they have no desire to parent the child. Now, I can't say that with certainty, but when I used to represent traditional surrogates where they were the egg provider, in every single case, I'd hold my breath, we'd all kind of hold our breath and hope that, because there was some type of bond there. However, there were never any contests. But with gestational carriers, I see a different picture.
Senator Archambault and then Senator Lombardi.
Thank you, Madam Chair. Mike, first and foremost, it's good to see you, and I really appreciate the level that you put into this area of law, because you're really, from my understanding, in a truly unique position. I mean, there aren't a lot of Mike Grants out there who really do this kind of work and can help the state to come into a codified system which helps people with surrogacy. So thanks for I know this comes from your heart and you really care. To go back to your point about surrogates who actually use their own eggs, to be clear, you can't divest somebody of a property right to their own child, right? And that's the problem. So if you use a surrogate who's actually using their own egg, at any time they could say, we don't want to give the child up to the parents who want the child, and you can't really contract that right away, right?
No, that's correct. That's right. And this bill provides the surrogate 3 days after birth to withdraw her consent to the agreement, and if she desires to have some type of right to the child, which I think is proper. I think they should have some time frame to reflect after birth, and this bill does provide that. So, and that contract has to be approved by the court before anything happens, which is good in a traditional a genetic surrogacy context, because all the parties are brought into court beforehand. I think that's very important, where the carrier is also the genetic mother. So this is serious, and she has to entertain exactly what's happening here, and the parents as well. I always warn parents. I don't represent many that are matched with genetic surrogates any longer, again, because the technology is so good. But I do caution them. You have to understand that if this carrier delivers, and immediately after birth, if she wants rights to this child, she's going to get them. And I caution them, just to protect myself and to protect them. They need to know that.
One more question. Out of 300, 400 surrogacies that you've done in your career, how many have been, roughly, just percentage-wise or numerically, how many have been surrogates who use their own eggs?
Maybe 15. Yeah,
Thank you.
And years ago.
Thank you.
Thank you. Senator Jabour, I cut you off. I
Oh,
apologize.
that's okay. Is Senator Lombardi finished? That's fine. You all set, Senator? Okay. I just had one other question on the issue where we're coming into line with what other states now have already legislated. Is that fair to say?
Yes, yes, absolutely, many states.
Do you know of any states which have a law which prohibits or restricts these type of agreements?
Yes. New York has a law that holds that any contract, surrogacy contract, is not binding. Michigan prohibits surrogacy. There are some other states, and I could provide a report to the committee.
If you could do that, that would be helpful, because I would be curious as to how the courts then interpret, or would they permit the same type of hearing that you've described here in Rhode Island?
That's fine, I can certainly.
Do they provide the same type of hearing?
I don't think they entertain any, there may be a judge in certain counties that just firmly believe that, you know, it should be done in that state, it should be acknowledged and workable. I can't say honestly.
Thank you.
New York, there are some counties where things happen, but
Thank
I haven't
Thank
been
you.
privy.
Senator Lombardi.
Thank you. Mike, typically, I always am inclined to support uniform laws. I think it makes sense this way, that there's some predictability around the country. But I want to just hone in on what you said about Presiding Justice Gibney retiring. And I'm curious, is it your, let's assume things don't happen overnight sometimes in this State House. It takes perhaps a week or two to get things done over time. But assuming for the sake of argument, this bill doesn't make it through, do you sense or do you predict some sort of resistance from future potential presiding justices of the Superior Court to hear such cases?
I don't. I can't say I do. I've spoken to several other justices of the Superior Court who are positive about it and feel, as Presiding Justice Gibney, that the court has jurisdiction and are in favor of it. But certainly a statute would be.
Oh, no question about it. No question about it. I'm just concerned
Yeah,
about,
no.
this interim period. Thank you.
I can't say.
And this is an issue, Mr. Grant, so you know, that I had dealt with Chief Judge Bedrosian on years and years ago, and one of the problems was that it was one piece within the Uniform Parentage Act. It wasn't the whole act, so we had some different groups. I think GLAD was one of them, in the ACLU. If I remember correctly, I met with Steve Brown and a national representative from GLAD, and their concern was that they didn't want us to cherry pick, so to speak, different issues. They wanted either the whole act or nothing. So certainly, just so you know, this is something that I need to give the family court an opportunity to weigh in on. I know Sharon O'Keefe had prepared to come, but was ill today. So certainly this is something we would hope to work on and take back up. With that, at this point, Senator Nessa Bush is going to move to hold 2303 for further study, seconded by Senator Archambault. All those in favor signify by saying aye. Aye. Opposed? The bill's held. Thank you very much for your testimony.
Thank you very much.